Isolation, Professor Alan Patterson, the Centre for Professional Legal Studies, Strathclyde University. Good morning to you, Professor. Thank you very much indeed for attending. Going straight to questions, can I ask you how satisfied are you that the bill addresses the specific issues examined by the working group on the legal services market in Scotland?
Well, thank you, Convener. I should start by declaring an interest that I have connections with the Scottish Legal Complaints Commission, Citizens Advice Scotland, SLAB, and the Joint Standing Committee on Legal Education, and have had connections with the Law Society serving on the Council. So I should make it very clear that I'm here in my personal capacity as an independent academic. Your question was, to what extent did it answer the issues raised in the Joint Working Party? I'm not sure the Joint Working Party. I think it left a number of questions up in the air, that Working Party. In some ways, I'm not sure how far the debate has moved forward on the fundamentals, but the Law Society has voted in favour of it, the government's in favour of it, so we now have the bill.
Well, we have the bill, but we don't have the Act.
Very true.
Cathy Craig.
Obviously, Professor Patterson, you've got a foot in every camp, it seems, in the legal profession. But the Law Society's opinion on this whole issue changed considerably in the space of just a year or so. Have you any idea why solicitors were able to come together like that and change their views?
Oh, it's a very interesting question, and I was on the Council of the Law Society when it happened, but I can't. Being on the Council of the Law Society doesn't mean you're privy to all the internal debates that go on at the upper reaches. One suspects that the large law firms made their views very clear, and I think that had an influence. But I also have to report to you that, I don't think this is private, the vote of the Council in relation to ABSs was very solid. Those of us that were in the minority were very clearly in the minority, and those that were in favour had quite a strong, solid majority, and they were not individuals from large law firms. These were people from high street firms, from rural firms, and so on. I was surprised at the degree of support that alternative business structures attained. So it must be the case that many such individuals see opportunities.
Thank you.
Professor Patterson, that you do not think that the status quo is an option?
I'm not sure the status quo was fully understood or developed. The status quo allowed multidisciplinary practices. And there is no problem with multidisciplinary practices, that is, different professionals working in the same firm, provided one professional grouping, if we're talking about legal services, the lawyers are in charge of the firm, are regulated to be in charge of the firm, have the responsibilities of running the firm and complying with the professional standards and now the regulatory objectives. That, to me, doesn't pose problems. You can have some disciplinary problems for the non-lawyer professionals and the non-lawyers within the practice, but the way you deal with that is to hold the professional partners, the lawyer partners, responsible for their non-lawyer colleagues, and that's how it works. And it's a very effective mechanism. All the advantages of multidisciplinary partnerships are with a multidisciplinary practice, except you can't give the non-lawyer partners, or non-lawyer members, a share of the profits. You can find ways of doing that, which are quite legal, but with a bit of imagination. And I never understood why those who wanted what was called a legal disciplinary partnership, that is, to bring in or to allow their HR partners or their their HR staff or their IT staff who were important to their organisations to have an equivalent say in the operation of the organisation. I always thought that that was possible with a degree of imagination, but they felt that they really needed to be made partners, and that's why the drive to multidisciplinary partnerships at that level.
Nigel Dawn.
Thank you very much, Convener. Could I just pursue that very briefly, Professor Patterson, because I was speaking to the previous panel about the fact that it seemed to me the door was already open to doing precisely the kind of thing you've been suggesting, and surely if your HR boss, but not director, was on some performance-related pay, then, you know, I mean, bonuses, of course, are not flavour of the month, but surely it's not even particularly difficult to get most of the economic benefits that we're talking about without having to change the legal structure.
I'm afraid I'm in agreement with you on that, but that, you know, my viewpoint didn't prevail on Council.
Right, thank you. I wonder if I can go back to advocates, because your written evidence to us describes the statutory framework, I think, as skeletal, which is a very fair comment, given that I presume you were referring to, what was it, Section 82, I think, which really doesn't say very much at all. And I'm just wondering whether you could indicate what kind of additions you think should be there, please. Sorry, it's not 82.
No, you've just got to look at the Solicitor Scotland Act and the provisions that are in here for an approved regulator, and you can see that when it comes to regulation, you can go a lot further than 3 sections. Now, I'm not necessarily saying we should go that far, but in the 21st century, the notion that there should be a consumer and public input into the regulation of professions is being widely accepted over a whole range of professions, and I think that the faculty, having accepted it in relation to complaints, should see that it's the way forward as it is for the Law Society in Scotland, it's the way forward with the Law Society in England, it's the way forward the Bar Standards Board in England and Wales, it's the way forward in many professional organisations to make sure that the public interest is fully recognised. Because I don't, if I have the opportunity, I don't believe in separating the regulatory and representative arms of the profession. I think it's very important indeed. I think it's vital for the future of a healthy profession that it keeps the professional interest and the public interest and holds them together in tension, as Section 1 of the 1980 Solicitor Scotland Act requires.
Right. Forgive me, it's actually Chapter 2 and it starts at Section 87, just so we get the record right, because I'd forgotten the number. My previous discussion suggested to one of the witnesses that regulation by the court ought to be adequate. Do you not feel that that's adequate under the circumstances?
Not in the 21st century. I think we have had in Scotland in the past a slight tendency, whenever there was a tricky regulatory problem, to sort of say, oh, we'll give it to the Lord President. Well, I think that leads to overload, or the potential for overload, particularly if we don't give the Lord President the staffing and the office and the support that he or she would need to carry out this function. There has been a slight tendency, I think, to leave everything to the Lord President and assume that whoever holds that office can carry out more and more functions. And I think that's not a tendency that is a good tendency in regulatory terms. I've no objection to the Lord President having a role here, but I think that if the Lord President, for example, is to play a role in approving, along with the ministers, then I think the things that apply, some of the things that apply to ministers should apply to the Lord President. In other words, that he or she should be asked to or expect to receive the comments from the consumer and other bodies and whoever is consulted under the regulations, the sections of the bill, and you know, move in the direction of a modern regulator.
Does that necessarily mean we have to go away from the Lord President as being notionally the right person? Do we just have to make sure that he, or possibly she in time, has the appropriate staff
appropriate staff
to do that. I mean, that might be cheaper than actually generating another body.
Indeed, but also it is approachable and expects to